All right, good afternoon, everyone. Welcome to today's webinar, What Providers Can Expect at a Board Hearing. This is part 3 of our 3-part series, Mastering Licensing Board Investigations. To our returning attendees who have participated in the previous session, it's great to have you back. And to those who are joining us for the first time, we're glad to have you. We will be sending a recording of parts 1 and 2 in the follow-up to this webinar in case you'd like to catch up on the rest of the series. Today's agenda is going to cover 3 issues: strategies for effective board hearing preparation, avoiding common mistakes at hearings, and exploring post-hearing options from consent orders to formal board complaints. By way of background, Fryer Levitt is a national law firm with offices in Pine Brook, New Jersey, and New York City. Our 45 attorneys focus exclusively on healthcare and life sciences industries. My name is Guillermo Beades. I am a partner in Fryer Levitt's Healthcare Litigation Department and co-chair of the firm's Insurance Defense Group. My journey has been deeply intertwined with advocating for healthcare professionals across a wide spectrum of legal challenges. I take pride in serving both practices and individual healthcare providers, guiding them through the complexities of administrative, civil, and criminal healthcare matters. My experience extends to a variety of arenas, from state licensing authorities and medical boards to federal healthcare agencies such as OIG, CMS, and the DEA, as well as state healthcare agencies like the New Jersey Medicaid Fraud Division and New York's OMIG. Joining me today is my colleague, Alan Blankstein, an associate at Fryer Levitt. Alan's practice focuses on administrative law matters, Medicare and private payer appeals, government investigations, and board matters. Before Fryer Levitt, Alan was a Deputy Attorney General at the New Jersey State Office of Attorney General, handling professional board prosecutions. And now we'll get started with our webinar, and I'll turn it over to Alan to talk to you about the initial preparations that you should take when approaching a board hearing.
Great. Thank you, Guillermo. Thank you for that introduction. So typically when we get a client who is retaining us after they have received some sort of a letter from the board telling them that they have to come in for a hearing, the first question is, what do I do? What do I need to put together? What do you need to know? So if you do get a letter from the board requesting that you come in for any kind of a hearing, and we'll go over some of the different types throughout this presentation, the first thing you should do is look at the letter, determine if it's about a patient or a particular part of your practice, and then gather all the relevant documents to whatever that inquiry is. If there have been any past correspondence with the board, was there a previous board complaint? Did you submit records pursuant to a subpoena? Anything like that. Gather those documents, gather the patient complaint, the response, if those exist, the treatment records for the patient or patients in question, and then any other documents you may have received or given to the board at all, either tied to the investigation they're currently conducting or from a previous investigation. One of the things that Guillermo and I will do when we're preparing for a board hearing is we'll put together something that's similar to a trial binder with all the relevant documents organized so that we can quickly reference them. And it's good as the respondent to a board hearing to have something similar, because we always like to advise our clients this isn't an open book test. You can refer to your notes, and having those notes at the ready makes it very easy to respond to board questions, as well as appear overall competent, which is one of the predominant things you want to do when appearing before the board. You'll also want to review the scope of questions and areas of concern in the appearance letter, just to make sure you have all the relevant documents. As I noted, sometimes they'll be requesting to speak about a specific patient, sometimes multiple patients, sometimes your treatment of a particular area of medicine, sometimes, but very infrequently, it's just a general talk to you about your practice overall. If that happens, obviously there needs to be a further discussion to figure out what prompted that, but that's very uncommon that they'll call you in for such a generic reason. You'll also want to, if this is the first time you've responded to the board, or if you've responded to the board previously but without the assistance of counsel, you'll want to put together a narrative of all the facts and circumstances related to the allegations. Sometimes when you respond to a patient complaint, you may leave certain information out for good or bad reasons. But when you're discussing this with your attorneys or even preparing on your own, you'll want to be as honest as possible and have a very thorough narrative to understand exactly what you're going to be discussing. And then, the most important advice we can give you is to contact an attorney to set up a prep session to go over all of the questions you may be asked, as well as to organize the evidence and see what really is relevant, what isn't relevant, what you will need to have at the hearing, what you wouldn't, and areas that you may want to avoid.
That's correct, Alan. And when we talk about preparing for a hearing, it's akin to preparing for a deposition. I've talked to many med mal attorneys. I've done a little bit of med mal in the past as well. And the purpose of the prep really isn't to tell you what to do, what to say. You're going to know what to say most of the times, but sometimes the way you say it, the way you word it, can be taken the wrong way. So part of it is talking to you about, going through the questions and answers that we anticipate you're going to receive, at least the legal ones, what the DAG will ask you. And I think Alan and I have done a pretty good job. I think we're batting, pretty high there. I think we got about 90 to 95% of the questions the DAG usually asks in our prep. Where it's a little different and where we can't foresee every question is where we get to the clinical aspect. But we're not worried too much about the clinical because, at that point, you're the subject matter expert. You know your field. What you're supposed to say, what's supposed to happen. If you're an OBGYN and you're getting questions about, what happened during a particular prenatal care or during labor and delivery, well, you're going to be able to answer those questions. We're not going to be able to prep you on a particular article from an authority, but we are going to be able to prep you as to how to answer in the sense of if you give us an answer that sounds a little off, or that could be taken either way, we want to nail down exactly what you mean so that it comes out and it reads in the transcript exactly how you meant it. It's no different than prepping for a deposition if you have a civil trial. And again, a lot of this is to demystify the whole process so that you're comfortable when you're answering and you're not being blindsided. So part of that is understanding your case. So how you understand your case. The first thing is we want you to review all relevant patient records, every document, anything that refers or could be connected to an area of concern. What we like to make sure that you understand is that, as Alan mentioned before, it's an open book test. Now, you can still fail an open book test. So what we like to do in our prep sessions is pepper you with questions. And we've been told more than once by our clients that our questions were harder than the board a lot of times, and that they were more nervous answering our questions than the board's question. Part of that's because we know your case really well, too. We've reviewed all the relevant records. We're looking at every single weakness and in the documentation, anything in the arguments that could be taken a different way. And we really hammer down on areas of concern, of risk. The easy questions are easy questions. Alan's going to go over in the next slide some of the questions that you're going to go over when you're preparing, or I think it's a couple slides from now. And what we want to make sure is that you review all your records, not so that you know them like the back of your hand, but you know where to find certain records. If we're talking about hypothetically an OBGYN, and the OBGYN has to talk about the labor and delivery of a problematic delivery, we want that client of ours to be able to find within the record, maybe it's within the nurse's notes, maybe it's within, the delivery notes, maybe it's within a different provider's consult notes, the information needed to be able to defend your case. So that's where we say, review it, understand where things are. You don't need to memorize it, but just have that roadmap in your brain so that you know, okay, this is where I need to look for it. And when you're talking about where do I need to look for it, you're going to look for it in your notebook. We usually create either a PDF file with different sections on it, or a physical notebook with tabs on it, like in the old school days, that includes medical records, background info, CV, CME certificates, which we'll touch upon later, and any other relevant documents. Maybe it's an independent expert report. Maybe it's the patient complaint that we may have to reference, whatever it may be. But everything that's relevant that may come up in that hearing, we'll have in a notebook prepared for our clients. And we'll share it with them, and we'll make sure that they understand where things are, and we will prep them with use of that notebook. Again, you want to work with your counsel and have a mock hearing. Usually the way that we do it at our firm is Alan and I will sit down with our client. Alan, a lot of time, will read from a script that he created when he was at the Deputy Attorney General's office that is still used to this day. So we'll see new DAGs questioning our clients and basically reading from a document that, Alan was reading to our client, just a few days earlier. So it just gives you a sense of comfort, gives you a sense of relief, because you can see that, okay, this is exactly what I'm expecting. It's very good in that sense. Then when we're talking about drafts, we want to draft a closing statement that briefly highlights both your career accomplishments and disputes any of the complainant's allegations. So Alan will take you through some of the questions you can expect at a hearing.
Yeah, so every hearing essentially will start out with the same introduction preamble where they'll introduce the different board members. There'll typically be, depending on the type of hearing, between 2 and 4 members of the board medical examiners. There may or may not be a physician who is employed by the board of medical examiners as in their executive committee, but not a voting member, and there will be a deputy attorney general as well as a stenographer. They'll introduce all of these people. They'll explain all of that. They'll explain the purpose of the hearing, and then they'll swear in the person who is appearing, the respondent. After that, they'll ask a number of background questions. All of these questions are questions that you will know. They're about you. They're not trick questions. They're not challenging questions, and they're a good opportunity for the person who is sitting there to overcome any nervousness, to get familiar with the Deputy Attorney General, to kind of develop a rapport, and to show that they're competent about the easiest thing, which is their own background. These questions will include the medical school that the respondent attended, any board certifications, areas of specialty, subspecialties, anything like that, any states that the respondent may be licensed in outside of New Jersey, malpractice and disciplinary history, and hospital privileges, current hospital privileges, your current practice. Depending on the allegations, it may ask the size of the practice, any other licensed staff that work at the practice. A lot of questions like that. I've had cases where I asked the number of patients that a physician may see in a week, how many they may see in a day, how many different services are provided at the practice. It really depends on the specific allegations in a lot of cases, but generally they will ask you questions about your personal background, and it's just a good way to get into the flow of things. So it's very important to know all of this stuff, because sometimes people forget what states they're licensed in. They may forget the specifics of the malpractice cases that have been brought against them, been settled, been dismissed. And you just don't want to show up and not be able to answer very easy questions. So, when we prepare our clients, we'll go through every single one of these questions so that, anything that the client may have forgotten, they'll be able to refresh their recollection, as well as just kind of understand what the flow of these hearings are like. Then they'll ask you about your current CME status. This is where the employed doctor of the board, typically it's Dr. Harry Lessig. I believe he's the only person that's they're doing this right now. We'll ask you about your current CME status. You'll have to, before the hearing, give them copies of the certificates from your CMEs. It's important that you keep these certificates. The board requires that you keep them for 6 years. So you should have the ones for the time that they're requesting, because it's usually either the most recent or the current term, or biennial registration. Then they'll turn to specific questions about the patient or patients at issue in the complaint. This is where we as attorneys can ask you a lot of specific questions as they relate to what we read in the medical records and that we may know from previous patient complaints, but obviously we're not doctors, so we can't ask you anything that gets too into the specifics. Depending on the allegations, depending on your specialty or subspecialty, the doctors who are at the board may or may not have a lot of questions when it comes to this. If it is something where other doctors that are sitting on the panel are that same specialty and they feel that you did something wrong, this is where it can get a little dicey for doctors, because typically the doctors on the board don't want to get too into the details if it's not something they know a lot about. They may ask you some general questions, and if it's like a general type of issue, they'll have a lot of questions. But if it's something in their specialty, this is where there can be a lot of disagreement. And it's just important to really understand your medical decision making at every stage for the patient or patients that they're asking about, because even if they disagree with some of your decision making, if your decision making is within the standard of care, if you can explain why you made those decisions in a way that follows the medicine, that's almost always the best way to defeat allegations by the Board of Medical Examiners. So it's just very important to know your case, to know why you made the decisions that you made, and to know that you followed the right standard of care in that specific case. So that's really the point at which these types of hearings, no matter how prepared you are, can go off the rails depending on who the actual board member is asking the questions. But again, as long as you know what you did and as long as you can explain your decision making, that'll protect you in most cases.
Yeah, it's well said, Alan. And to add a couple of points to what you said earlier, also, when we talk about the personal background questions, they serve two purposes. One, they ask you these ahead of time, early in the hearing. It's to get you comfortable. They understand that this is a stressful situation. They want to get you in a groove, answering some easy questions. These are softballs. You don't have to know what year you graduated medical school, and you don't need to know things that you may forget after a while, or you may think, oh, what was it this year or that year? That's what your CV is there for. It's going to be in your trial notebook. You're going to be able to take a look at it and answer those questions. This is one of the purposes. The other purpose is, if you're going to lie here, they're not going to believe anything you say later. So if you're going to lie about basic background information, if you're going to hide the fact that you had a malpractice, which they know about, if you're going to, deceive them about anything that's very easy to verify, that really hurts your credibility going forward.
Right.
So the background questions really serve those two purposes. And also, to Alan's point, you have to keep your CMEs, because they're going to ask you about your CME status. And most states, including New Jersey, have CME, have board regulations that require you to keep your CME certificates, or if you're a nurse or psychologist, whatever your specialty is, your continuing education credits for a period of usually 7 years. That's because, you can be audited on your CME compliance. And if you don't have the CME certificates, if you don't have proof that you took these courses, what's going to happen is, at a hearing, you may not get disciplined for any other reason, but you might get disciplined for failure to comply with the CME requirements. And that's going to be, I think the last calculation was anywhere between $25 and $50 per credit that you failed to prove. And when you have, 100 credit hour requirement, it can be a considerable fine. So please keep your CMEs. And then again, just like Alan said, it's essential that you understand the medical decision making involved. Most of the time, the board will try to have at least one panel member be of your specialty, but that's not guaranteed. So sometimes you may be in a unique position where you're kind of educating the board on your particular specialty, particularly if you're in a subspecialty. So there are some frequent mistakes we want to talk to you all about right now. One of them is easy: not gathering all relevant documents, including CME certificates. There comes a time every once in a while where the board may ask you a question that you don't know, and you can answer I don't know, or I will get you that later. You don't have to guess. You're there to tell them what you know. So not having every record isn't a cardinal sin. Sometimes they might ask for records that, we don't even anticipate that they want to see. That's fine. That's a post-hearing submission. That's something that you take care of after the fact. But when we're talking about gathering relevant documents, I mean documents that you really should expect to have to prepare to present, like the medical chart, your CME certificates, things that are important. The second one happens every once in a while, and it's frustrating from our end. It's when you withhold information from your attorney. Your attorney is your zealous advocate. That is what we are required to do by our rules of professional conduct. We are supposed to zealously advocate for you. Sometimes we come across situations where clients think that if they tell us a version of what happened, not 100% the truth, or they withhold something, that will advocate more for them or that will believe more in their case. The best way any attorney can represent you, doesn't matter if it's real estate law, doesn't matter if it's a civil lawsuit from a car accident, or if we're defending your license before the Board of Medical Examiners or Psychological Examiners or Board of Nursing, it's the same thing. We need to know everything in your case. We need to know the warts. We need to know your malpractice history. If we go into a hearing and we are not prepared, they're not going to say, okay, we'll adjourn it because you didn't know that your client got a DUI 3 weeks ago, right before the hearing. We need to know everything, whether something is current, something in the past. Sometimes we'll have clients say, well, I didn't think that was relevant. We'll decide what relevant is, okay? But we have to get 100% cooperation from the get-go so that we can do the best job for you. We've had some very difficult cases, some very complicated situations. We've defended cases where, a surgical procedure was done on the wrong side of the body. We've had situations where, a patient died on the operating table. We've had disruptive physicians where there was violence involved. We've had a lot of really complicated cases. But when we know what to expect, when we know the history, we know the background, we know all the dirty, details, we can set realistic expectations, and we can then better prepare you for some really tough questions that you are going to have to answer. Failing to review records prior to the hearing, again, with the understanding that you don't need to have a crystal clear memory. You don't have to be one of these people that can recollect every moment of their life, and that this is an open book test. Not reviewing at least the hearing notebook, not understanding the medical care provided to a patient, if it's a board complaint that relates to that, that can really hinder you. Because while it's perfectly acceptable for you to say, you know what, board members, let me take a look at my notes for a second, and I can tell you when's the last time I did a urinalysis on this patient. That's a lot different from, oh, I don't know if I did urinalysis. Wait, let me check. And then you're just in front of the board flipping through pages for 5 minutes. You don't look prepared. You don't look like you know your patients. It's a bad look. So understanding, again, generally where to find things in your records, understanding what's in your record and what's missing. Let's say it's a case on opioid prescribing, and you didn't do random drug testing. You didn't check the PMP enough. 1, tell us, don't withhold that. And 2, we'll figure out together why that happened, how to answer that, how to explain. We're going to have a theory of the case, a theory that we're going to keep going back to at the hearing. How does this fit within the theory? What happened? Why was there an oversight? What have you done to correct it going forward? There are ways that we can try to navigate through some of these choppy waters. But again, you have to review your records, you have to be open with us, and you have to gather all these relevant records. Last, not setting aside enough time to prepare with counsel. If the more complicated your case, the more likely you're going to need more than one hearing preparation. Hearings are one shot. That's it. You get usually 1 hour. Sometimes they'll go to an hour and a half, and that's it. That was your one shot. They might come back with more questions after the fact, but you usually only get one shot at a hearing. So you really need to set enough time to make sure you're thoroughly prepared for everything that could come up at the hearing. Alan will take you through some more frequent mistakes that we see at hearings, and then we'll wrap this up before moving on to the next section.
Sure. So the simplest one we see is either people who are too nervous. This is something you can come back from, and certainly, depending on how it presents itself, can in some ways be endearing to the panel, but it's not the best way to present yourself as a competent physician if you appear too nervous when you're before the board. So, that's why I recommend using that introductory period to really get comfortable and to, get over those nerves, because you've been speaking for a while and it's been very back and forth. And most people typically get over the nerves by the time they get to the real meat of the PEC hearings. The cavalier attitude part, on the other hand, is something that people don't get over. If they come in with a cavalier attitude, they leave with a cavalier attitude. It really makes the members on the board want to argue with you, want to fight with you, want to bring you back down to size, to impose their authority, more or less. And it just makes these hearings very difficult, and it makes them want to take whatever they believe is the worst action possible against you that they can take, they will take. So you want to go in confident. You don't want to go in with an air of smugness or arrogance towards the board, or dismissiveness that you shouldn't be there at all. Not answering questions directly. This is something I always try to go over with clients. The example I give is, if somebody asks you, is it raining outside? The answer is not, well, it's not raining outside today, but it was raining yesterday. It was pretty cold yesterday, and but it got warmer in the day. The answer is either yes or no. And let them ask the follow-up question. Let them ask about the weather yesterday. Let them ask, whether it was warm or cold. Answer the question they ask you, and they'll learn. If you're doing this, they'll learn to ask better questions throughout the hearing. If they know they can ask you something simple, and you'll just start rambling, they'll do that. So make them ask you the questions that they want answered, rather than giving them the answers they want, because it doesn't benefit you to be forthcoming in that manner. You want to be forthcoming and honest, but you don't want to be just saying whatever comes to mind to give them the answers that you think that they want. As Guillermo said, not knowing the medical records or other documents relevant to the hearing, this is just a big no-no, because it makes you look like you don't care, or it makes you look like you don't know what's going on, both of which are bad things. Failing to listen to the questions being asked. This is similar to the not answering the questions directly, but it's more dismissive. It's when people aren't really paying attention. They're just kind of answering whatever they think that the board may want to hear. Make sure that you're engaged. It's pretty easy. These are very high stress events. You should be engaged the entire time. If you ever were to have a question asked that you didn't understand, you don't have to answer the question you think that they asked. You ask them to repeat their question. The board members understand that it is stressful and that it can get a little confusing, and they'll sometimes ask multiple questions. Nothing wrong with asking for clarification. Volunteering information. This is worse than not answering questions directly. Sometimes people will just volunteer information as a way to what they think is either get this over with, or to just kind of lay down at the mercy of the board. Don't do this, because there's no reason for it. They're not going to take pity on you because you told them what you think they wanted to hear. Make them conduct the investigation. They may find out whatever it is that they need to find out to do something, but make them do it themselves. Having the wrong attitude or demeanor. Really, the attitude you go in with can save you in these board matters. A lot of this is based on the board members' judgment about whether or not they think that you are a danger to the public. If you come in, you appear professional, you appear competent, you appear confident in what you did. If you did something that may have been on the fence of right or wrong, they're going to look at you as a colleague and say, if I was sitting on their end, how would I react to this? Would I think that I should be disciplined? If you come in as an antagonist towards them, they're going to feel like they need to do something to knock you down a peg if they can. So just go in with a attitude of confidence, competence, and collegiality, and that will do you tons of favors throughout the entire hearing and the entire investigatory process. Embellishing experience or credentials. This can come in two forms. This can come in either just kind of bragging about credentials that you have, but they're not really as impressive as they may be. This can come into problems if you're advertising to patients and misleading them, but oftentimes it's really just kind of trade puffery. But it also comes in the form of people lying to the board about what their credentials are. They may say they're board certified in some subspecialty that doesn't have board certification, or they may say they're board certified in a specialty and they're not board certified. Both are bad. Both can get you public discipline. If you lie about it again to the board at the hearing, you get more public discipline. You can be disciplined both for lying to the board as well as for lying about your credentials. I've seen this happen both on the defense side, where somebody has lied about their credentials, and I experienced it on the prosecution side, and I saw the board deliberation in the private setting about it, and that's something that they really don't take kindly to. That's almost number two in terms of the list of things that the board is concerned about. Number one is protecting the public from bad medicine. Number two is protecting the public from people they feel are liars. And if you're embellishing your credentials or experience in a way that is fraudulent, they will take extreme measures against you. So the best advice I can give you is just don't lie. Don't lie to the board, and don't lie about your credentials prior to any kind of a board investigation.
Yeah, and just to echo that sentiment, Alan, we had a case many years ago where we had a provider who said they had studied under a renowned person in their field, and the board followed up with that person, and they had no record of them ever, studying under them. Turns out that they attended a weekend course that person was teaching. That's hardly how it was being represented on this person's website, how it was being represented to the board. You're not studying under somebody if you took, a 1 hour, continuing education course by someone who's renowned. So it's things like that the board really clamps down on. And the real takeaway from that anecdote is that the board does their homework. They follow up. If you say, well, my monitor, Dr. Smith thinks that I'm the best person they've ever seen, I don't need to be monitored by them anymore, and I should have my license back completely unrestricted, they're going to call that monitor. And they're going to say, did you say these things to this doctor? Is it true? How does this doctor compare to other people you're monitoring? Are you willing to put that in writing to the board? And that's one way that people get in trouble, by being overconfident and embellishing things. Another thing I wanted to touch upon before we move on to the next slide is that when we're talking about volunteering information, we see that happen most often when there's no question on the record. And that's something that, it's like a pet peeve of mine. You answer questions directly, but also the caveat is you only answer questions when you're asked questions. So sometimes you might be asked about, are you board certified in, psychology? Yes, I'm board certified in psychology. And then there'll be a pause because the DAG might be looking through their notes. And then my client will just start giving just an answer. Just start answering, no question, and start talking about the case or their credentials or their and at that point we interject because they're represented by counsel, and we say, excuse me, there's no question on the record, you don't have to speak right now. But if you don't have representation and you go by yourself, you may be getting yourself into a lot of areas where they'll listen to you, they'll gladly listen to you, and then they'll form questions based on whatever diatribe you went on. Also, failing to listen to your attorneys when they try to object, give your attorneys a chance to object. Sometimes the DAGs or the board members will ask bad questions, compound questions. They'll ask 3 questions in one. That's not proper for something that's going down in a transcript. So we object and we say, please, objection, multiple parts. We'll answer each question separately, but please ask them individually. And I'll be honest, a lot of times the board just forgets to follow up on the questions. They ask their first question and the other 2 parts of their questions, they forget about them. So, you know, it's not a strategy. It's just something that we do, and sometimes it works even better than we intended to. But listen to your attorneys, let them object. Listen to your attorney's objections. Alan, if you want to take this one, because after the hearing, this is where things can slow down again and we can have a little bit of a lull before something else happens again.
Right. So immediately after the hearing, in some cases, we will do a post-hearing submission. Typically, this only happens in 2 circumstances. The first of which is when, well, 3 circumstances. The first of which is when they don't have the CME certificates for whatever reason, and we need to submit the certificates, or something wasn't submitted. One of the certificates wasn't submitted. We need to resubmit it. The second circumstance is when a record or document is brought up during the hearing that either we don't have or they don't have, and we want to show them. We'll do a submission of additional documentation. They're almost always willing to accept some additional documentation if it matters to, you know, the final disposition of what they're going to do. And the third time is when something comes up at the hearing that there's a confusing answer given, or an unclear answer, or sometimes even a wrong answer. Sometimes, you know, you get nervous and you say something that's not accurate. It's not that you're trying to be misleading or dishonest. You just say something that's not accurate because you weren't expecting it. It's not part of the records that you had, because these are plenary hearings. They can ask you about anything. And in that case, we'll submit an actual formal submission where we kind of give a narrative explaining an answer to the question and reframing the question in a way that's the most positive to you. You know, it's not always something that happens where we give a post-hearing submission. They typically don't want them, but in those circumstances, they'll allow us to give them, and it gives us another chance to advocate on your behalf. So it's not a bad thing to have to give a post-hearing submission. The board may follow up on certain testimony. You know, as Guillermo noted in the previous slide, you know, sometimes if people are just not saying things that are true, they may have follow-up questions if they research it and want a better answer, a more clear answer, or giving you another opportunity to give an honest answer, which if they're doing that, take that opportunity and run. They usually don't follow up on testimony, but if they do, make sure that you give an answer that's honest. As I noted, they may ask for additional documentation or supplemental testimony. It may not coming from our request, it may come from them. That only happens though in a case where either the client brings something up that they need additional testimony on, or the client brings up some kind of documentation that they don't have. Maybe it's a board specialty certificate or something like that. They may ask for additional documents. And then finally, our job is to figure out what's going on following the hearing. We have our impressions. I have my impressions based on having been on both sides of this and having done a ton of these and having experienced the post-hearing private discussions amongst the board members. I have a sense of what they're going to do after, but I don't know for sure. So either myself or Guillermo will follow up with the Deputy Attorney General. We'll ask them, where are we? What are the next steps? What's the board thinking? Is this something where there's going to be some kind of discipline that they're going to want? Are they going to be offering a consent order? If so, what kind of terms are they thinking about? Depending on either the severity of the allegations. If they're severe, typically they'll hold this very close to the chest because they don't know what they're going to do. If it's not that severe, if they do want discipline and they want just financial penalty or something like that, they'll usually tell you if that's where they're going. But they're typically not going to give you too much information until the board has made a decision and issued its recommendation for any kind of settlement authority. So, because the way that it works is you'll appear before the board, you'll leave, or a panel of the board, and then you'll leave, and then the board will confer and vote to determine what their recommendation to the board is. So if the recommendation, just for example, is to recommend suspension of 3 years based on the allegations, that will then go up to the full board to ratify that recommendation. If they do ratify it, then they'll have a meeting with the prosecuting deputy attorney general, give them settlement authority, and then they'll contact counsel to offer whatever that settlement is. So until that ratification process takes place, they typically won't tell you what's going on because they really don't know if that's what they're going to do or not. But if it's something that's insignificant compared to some of the other cases that they're dealing with, they will oftentimes tell you what they're going to do. And once the hearing's taken place, in terms of a timeline, it can take anywhere between 2 months and over a year, more than that, before they come back and do anything. The board operates on its own timeline. If they don't think you're an immediate danger to the public, they don't have any immediate reason to resolve it. So they will take their time, but they will, in 99% of the time, at some point, want to close their file. So don't think that just because you haven't heard, it's gone away.
That's right. And just to cap the board following up, sometimes they follow up, but for good reason, because during your testimony, you might say that, the allegations are untrue. I did have a chaperone present with me. Please talk to my MA, Nancy. She was there with me. And then they'll reach out to Nancy and they'll speak with her. They might even bring her in for her own testimony, or they might call her on the AG might call her on the phone, and that would help your case. So it's not always bad when the board does some follow-up work. Sometimes we ask them to do it, or we suggest that they speak to somebody that we believe would be a favorable witness on your behalf. So when we have an issue, when there's an issue and the board feels that you need to be publicly disciplined, you're approached with a consent order. Many years ago, there was this possibility of keeping things off the radar by private letter agreement. There might be some jurisdictions in the US that still allow for private letter agreements, but New Jersey, for one, has completely gone away from it, which I think is not a good decision, because then it really forces their hand to either discipline you or not. When a private letter agreement in the past at least let them give you a unofficial slap on the wrist, and as a way of saying, we don't really like what you did here. It's not enough to discipline you, but if we see you again, or if you don't clean up your act, then we're going to come down on you harder. But now they don't have that. So they have to make a decision, and the decision is, do we publicly discipline you or do we not? If they find an issue that requires reprimand, they will present us with a consent order. The consent order first starts off with a preamble that says what the board's findings and allegations are. And they have to have that because you can't sign any agreement, even if it's a favorable consent order, or favorable terms, I should say. You can't sign one without there being an actual, reason for it. So there is going to be some negative language in there saying that you either failed to, comply with a specific board regulation, or you didn't document properly, or, you settled a malpractice lawsuit, and in their investigation they feel that, discipline is warranted based on the settlement and based on the allegations in the complaint. It's going to have some of that language. Consent orders really run the gamut. They can do some horrific things like take away your license completely, or you have it revoked. You can't get it back. Suspend it, limit it. We see that a lot in opioid cases, where they'll say, you can no longer prescribe Schedule IIs. Sometimes they'll say you can't prescribe anything that's a scheduled drug. Sometimes the limited scope, we've seen a little bit more in the last few years, where there's allegations of, a doctor, maybe, having an inappropriate relationship with a female patient or being accused of assaulting a female patient. We've seen some orders where they will say you are not allowed to see any female patients ever again. That's the most extreme. And we've also seen others where they say you can never see another female patient present without someone there, without a formal board-approved chaperone. So again, they can limit your license, they can suspend it, they can revoke it, they can just fine you. Okay, everything you said was fine. We're going to reinstate your license. But in reinstating your license, we noticed you're missing CME certificates. We can't unsee that. We're going to fine you for that. And then that's a part of a consent order. And again, the other thing that we see very frequently where there's enough to do a slap on the wrist, but not enough to really take your license and impact it, is where they tell you to seek additional education. So you might have to take a record keeping course. That's one of the more frequent ones that we see. Or if there's a behavioral issue, if this was a disruptive provider type of case where, you got into a fight with some administrators or staff or another provider, or if there's allegations or suspicions of substance abuse, if you got a DUI, they would send you to, here in New Jersey, the physician assistance program. In other states, each state has their own program that works hand in hand with the state. I know New Jersey nursing is RAMP. Each state has a different one. Some are more stringent than others. So if you have the opportunity to sort of forum shop, if you're licensed in like New Jersey and Pennsylvania and you're a nurse and you live in Philadelphia, but you practice in Mount Laurel, New Jersey, if possible, you may want to try to convince the New Jersey board to go under Pennsylvania's. That's something that, you're not going to know off the hand. That's why you work with Healthcare Council. We have a feel and we understand which programs are better than others, which are unduly punish you in a very disparate manner. They are unduly burdensome. We try to avoid our clients getting involved in those types of programs. Consent orders, again, are public discipline. So that's going to be reported to the National Practitioner Data Bank. And the National Practitioner Data Bank will then disseminate that reporting to everywhere where you're licensed, credentialed, so it's, hospitals, it's insurance companies, it's your med mal carrier, it's every state where you have a license. And then if you were disciplined, you're going to have to then self-report to other states because other states can also discipline you for essentially being disciplined in another state. It's called reciprocal discipline. And again, we get involved in there. Those are not, usually they don't retry the case. They say, you signed a consent order. Now you're going to sign a consent order with us. And we just kind of negotiate the terms there. It's not having to redo the whole thing all over again. So because they're considered public discipline, they're available. They're usually on your license. There's a link to any discipline you got from your board. You have to notify other states. And depending on those states' regulations, you may or may not be disciplined. For instance, I believe in New York, if you are disciplined in another state for something that would also be a violation of New York's professional rules, you're going to get disciplined reciprocally in New York. However, if they don't have a rule or they don't have the same requirement, stringent requirement in New York, and you were disciplined for something that they don't have in another state, they're not going to discipline you. So it's important to understand that nuance, and that's why you need to work with Healthcare Council if you ever get a consent order. If you haven't worked with Healthcare Council, you've been doing it all by yourself, and you get to the point where you get served with a consent order, please don't just sign it. Get at least a healthcare attorney involved then so that, we can help you. I think it's important to understand also that if you don't agree to a consent order and negotiations break down, you can't agree to the terms, you can't agree to anything, there's going to come a point where the board is going to say, all right, this is our best and final terms for a consent order. If you don't agree, we're filing a board complaint. And Alan, you can walk everyone through the wonders of the board complaint.
Sure. So the board complaint only happens really in the most severe of cases. This is not something that's common for most providers to have to deal with. It is really only in the case where a settlement can't be reached, and that's not very common. The slide says that a board complaint is also public discipline reported to the National Practitioner Data Bank. This is true. A board complaint is public. This is the first time that an investigation would become part of the public record, which is another reason to avoid getting to this point, because until a complaint is filed or an order is put out into the world, all of this is confidential, and having a complaint rather than a consent order out in the public can cause more problems, because obviously the allegations of the complaint are going to be as unfavorable as you can possibly imagine. These complaints are filed by the Deputy Attorney General's office. It's almost always the Deputy Attorney General at the board hearing, especially if it's a PEC. These DAGs don't turn over very often, and the case files are typically theirs from inception through to the end of the case. So it'll almost always be the same Deputy Attorney General handling the case. The cases are handled by a judge, an administrative law judge. These are regulatory judges. They're in Newark. I believe they're only in Newark, at least for the ones that handle the board matters. But it operates like a normal case. A complaint is filed, you file an answer, there's discovery, there's motion practice. It's not as easy to interact with the judges. The timelines aren't as stringent, but there will be an actual trial. There will be actual testimony. You will be able to testify. It follows very similar rules of procedure and evidence as the trial court, so they're a little different. The biggest exception is really the hearsay exception in an ALJ hearing is much less strict. There's a lot of hearsay allowed, which is not a good thing if you are defending one of these cases. Another reason that you don't want to get to this point. And there will be active negotiations throughout the actual administrative hearing. So, this isn't something where once they file the complaint, you can't settle. It is something where typically you're going to end up with less favorable terms if you settle after a complaint has been filed, although that's not always true, because every once in a while the board will file a complaint and realize that their allegations are going nowhere, and they may try to back out as quickly as possible, but don't assume that that's going to happen in your case.
Yeah, that's true. We've had situations play out both ways, where we had clients get really, really antagonistic with the board and say, I will never settle this, to then, okay, let's accept our offer. And they say, well, that offer was good before we forced us to file a complaint. Now it's double that discipline. And, they were not willing to walk away from it, even trying to get the ALJ and a mediator to get them to come back to their prior offer. They would not accept it. So I know usually when people say best and final, it doesn't mean best and final. There's always some room for negotiation. That's the old adage, but sometimes best and final does mean best and final. And with the board, that's definitely the case. The board complaints, though, have a very dark side to them, though, because unlike civil litigation, there's some real differences between a civil suit and administrative action. Here in New Jersey, for instance, there's limits on discovery. You can't get as many discoveries, depositions, things of that nature. You don't have a right to a trial by jury of your peers, which, in some cases, depending on the facts, you really would want to hear. You'd want, a jury of your peers to hear how the board has been brutalizing you. How is this, fair? I think a lot of times I would like to have these cases before a jury, because, they couldn't possibly believe how arbitrary and capricious the board can be at times with their licensees. But here's where it gets really scary. There's fee shifting, but it's for the board only. So they could file a completely frivolous complaint, take a year up of your time, cause you to incur legal fees, and then what happens? They decide to drop the case. And you're supposed to just be relieved by that and say, oh, thank goodness you came to your senses. If you, on the other hand, after a year, decided, okay, I don't want to go through this anymore. I don't like the fact that this is dragging on. It could drag on for years. I want my license, back, or I want my, any restrictions lifted. What can I do to settle this? They'll say, sure, here's a consent order to settle this agreement, and we'll dismiss the complaint. But now you have to pay us $75,000 in legal fees. And I think every single time in the last probably 5 or 6 times, every single one of those times that we've seen what the board has billed and compared it to what we have billed, the board's bills are usually significantly higher, which is preposterous considering, as healthcare attorneys, we have, boutique higher rates, and we put in a ton of time. And based on the work product they show us, we can't see how it would take even a fraction of that time. But again, that's something that you're going to be dealing with. So the final decision of the ALJ, if they find against you in only one of 15 counts, okay, well, based on that one count, you're going to have the legal fees that they incurred and investigative costs as well, from sending out investigators to talk to patients, to obtain the statements, whatever it may be. So it can get very, very large, that bill. Not to mention, you also have to pay for your own attorney that whole time. Here's where it's really scary also. The final decision of the ALJ is not the final decision in the case. It's a recommendation. Once the ALJ makes a decision, that recommendation goes back to the full board, and they can either accept the ALJ's findings, reject the ALJ's finding, or accept it in part, reject it in part. So that's where it gets a little tricky, because you can go through years of this, get a favorable outcome. It goes then back to the board to say, okay, we agree with the ALJ, but there's nothing to really prevent them from disagreeing. So that's one of the things that we're very concerned about when we're talking about board complaints. The last thing we just wanted to talk about, I know we're wrapping up right now, is the fact that there's sometimes issues that come up when you're complying with a consent order. So Alan, if you want to take like a minute just to describe the issues that happen when you're trying to comply with a consent order.
Yeah, so just briefly, sometimes the boards will enter in these or put in these consent orders very specific language about specific things. The one where we see it the most is when they require some kind of education. And typically, they'll offer you to take a certain class at a certain institution as part of this education program. Now, what we've found over the years is that sometimes the clients, and they do it within a certain time period. So they say, take this class at this institution within 6 months. We found that certain clients can't comply because they can't get into the class within the time period. They can't get into the class because the class requires a prerequisite that was never part of the negotiations and doubles the costs of complying with the consent order. And there's a variety of other things that can happen when it comes to complying with these very specific terms. So you want to make sure before you agree to any kind of term like that you do your research. You know that you can A, take the class if it's a class, B, that it doesn't require any prerequisites prior to taking the course, so that you're not on the hook for additional costs. And if that's the case, the board should have to put that in the order. And 3 is really just to push for more generic language. We like to always, whenever they're recommending education, put in something about how, either this course or another board approved similar course that would satisfy the requirements, kind of put the onus back on the board to make sure that they're working for you to make sure that you can comply. So it's just, that's only one example, but it's very important to make sure that for any of these terms that may have more than just you paying a fine, than you serving some kind of suspension, that you really understand and research and make sure that you can actually comply with these terms before you agree to them. And obviously, we'll, as attorneys, we try to do the same thing, but we only have so much information about what the client can actually do. So, it's important that you as the client also make sure you research it and communicate any issues to us as soon as possible.
So again, just to put a bow on that, the consent order isn't worth the paper it's written on if you can't comply with 100% of the terms, because failure to comply will end up resulting in stricter penalties another consent order, more discipline. And if you've lost your license or had your license limited, nothing's going to get lifted until you are 100% compliant. You are late $100 on $50,000 of payments. They're not going to even look at your application until that $100 is paid. So it takes time. It can be frustrating, we understand. But again, that's something that, we certainly want you to keep in mind. It was a pleasure speaking to you all and giving you a little bit of our insight into a situation that can be very stressful. But again, it's not something that you should be necessarily overwhelmed by, because there are things you can do to mitigate any kind of exposure. And we want to make sure that you're prepared. Reach out to us at Fire Levitt if you have any questions. If the board reaches out to you or a board investigator ever shows up to your practice, and we can help walk you through this situation. Thank you again, and have a great rest of the day.
Thank you, everybody.